afternoon. Let's get started with our hearing and have Natalie come up to tell us about it, please.
Thank you, Mr. Chairman. House Bill 2608 would remove provisions authorizing criminal restitution to be enforced as a civil judgment, and it also authorizes judicial districts to contract for collection services for criminal restitution. Section 1 amends KSA 2169. That's the statute that authorizes the judicial administrator and judicial districts to enter into contracts for collection services. Subsection E here is amended to provide that judicial districts would be authorized to utilize collection services of contracting agents pursuant to this section for the purpose of collection of restitution owed under an order of restitution. Section 2 amends KSA 216604. That's the statute that provides for sentencing options when a person is found guilty of a crime. That section is amended to clarify that garnishment as a method for collecting restitution would be conducted pursuant to Article 7 of Chapter 60. And it also removes provisions providing for collection as a civil case. Section 3 amends KSA 223424 to provide the orders of restitution are enforced pursuant to KSA 2169 and 216604B2 instead of KSA 4301 and 604304. This bill also repeals KSA 604301 through 4105. Those are the statutes that provide for civil enforcement of criminal restitution orders. Section 4 amends KSA 602310 to change a cross-reference related to the contracts entered for collection services. That statute currently references KSA 79719. That statute was transferred. And so this would change that reference to KSA 2169. Section 5 amends KSA 602403 to provide that undisputed payments made prior to a request for a release of judgment are voluntary and wouldn't be subject to refund or recoupment. And I can take any questions.
Questions for Natalie, Representative Wheeler.
It's been a while, Natalie, but when this restitution issue and on restitution for restitution, it was provided in the statute that the journal entry of judgment in the criminal proceeding can be entered of record with the clerk of the district court, at which time that restitution order becomes a civil judgment. Does that remain the same?
No. So, and I believe both the proponents and opponents that you're going to hear from today are going to talk to you about a Supreme Court case. This bill is proposed in response to a Supreme Court case that essentially said that you can't enforce those restitution orders as civil judgments anymore.
Thank you. Then I'll ask my questions further. You always answer mine correctly.
Any other questions for Natalie? Okay, thank you, Natalie. For proponents, we have Todd Butler.
Thank you, Mr. Chairman, members of the committee. My name is Todd Butler. I'm an attorney. My law firm, Butler & Associates, is a contracting agent pursuant to KSA 20-169. We collect court debt and restitution. We currently represent 13 judicial districts, which includes 29 counties, including Wyandotte, Johnson, Shawnee, and Sedgwick County. On October 15th of last year, the Kansas Supreme Court issued an opinion in the case of State versus Arnett. In that opinion, the Kansas Supreme Court found that many of the statutes that we use to collect restitution were unconstitutional. The decision by the Supreme Court was based upon Section 5 of the Kansas Constitutional Bill of Rights, finding that the making of the court order for restitution a civil judgment violated that constitutional right. Senate or House Bill 2608 is our attempt to bring restitution back. Shortly after the Arnett decision, the Office of Judicial Administration contacted each of the contractors that were collecting restitution at that time and ordered us to close and return all the restitution orders. So in my office, I have 38,000 names in our database of crime victims who we can no longer help. I think under the information we've received from the state budget, there's about $260 million in restitution orders right now. Unless an individual is currently in prison or under probation, there is no assistance for the crime victims in collecting any of those monies that have been ordered to pay. So it is our hope that House Bill 2608 receive your approval. There are two other minor matters that we attempt to address in 2608. The first is a Supreme Court decision of Stormont versus Harold Seavers. In that decision, the court found that the term under KSA 60-2310, paid or payable, under the definition of earnings to include wages that were paid and deposited into a bank account, making them exempt. The problem is that exemption never expires. And so the hypothetical here is Johnny goes and deposits $200 from his paycheck into his bank account. He does that for 48 months. He's got $9,600 in the bank account. Johnny then gets convicted of first-degree murder, aggravated battery, aggravated assault, aggravated kidnapping. He's ordered to pay restitution of $4,700 to the crime victim's families for the funeral expenses that he's caused. I can't collect the money that's in that bank account because it becomes exempt under Seavers. So we're asking for two words, paid or, to be removed from KSA 60-2310 to reverse that decision so that we can collect that money using a bank garnishment. Finally, there's the decision of Copperage. In that decision, Alan Copperage was ordered to pay $278 in costs, and he was convicted in 1994. Over a course of, I think it's 15 or 18 years, Mr. Copperage paid that money through his work release plan. Most of that money was paid after 2003 when the judgment, the order to pay costs, was void. So the court ordered the state to return that money. And so we have a simple provision put in KSA 60-2403 so that the money paid voluntarily by Mr. Copperage after the judgment became void is not ordered to be returned by the state. Mr. Copperage has the ability, and all criminal defendants, after the judgments become void, to ask for the court to nullify the judgment, to cease all actions, to collect that judgment. And once they do that, all action does stop. But we shouldn't be ordered, the state shouldn't be ordered to repay those monies. And if there are any questions?
Any questions, committee? Representative Carmichael?
Thank you, Mr. Chair. I'd almost forgotten how to use this microphone here in the room. Fortunately, I'm remembering. Mr. Butler, it's good to see you again, and I appreciate your expertise on these topics. First, I'd like to direct your attention to the exempt funds problem, that funds which are exempt, then when deposited in a bank account, oftentimes preserve that exemption from execution. And as you observe, that might well be lifetime. But you're proposing to amend, I believe, KSA 60-2310. Is that correct?
Yes.
Yeah, I have it in front of me, but I haven't read it in years. But my recollection is that this statute is applicable to, in essence, all collection actions, not just those arising out of the criminal courts. Is that correct?
Yes.
So, for example, if an injured worker were to receive workers' compensation benefits, which are exempt funds, Social Security, I think, may be exempt. I can't remember the whole list, but I think Social Security might be as well. And they deposit those funds in their bank account. As it stands right now, creditors cannot reach those funds on the theory that it's for subsistence to keep people alive. I think that's where it came from, maybe somewhere else. How are you proposing to change the general collection law through this essentially criminal statute? At what point would my elderly mother lose that protection for her Social Security check once she's deposited in the bank?
This amendment is to KSA 60-2310, which speaks to wage exemptions. And the section we're asking to amend is the definition of earnings. Under 60-2310, section A1, earnings currently means compensation paid or payable for personal services. We're striking or asking to strike the word paid or and just leave the word payable. So the wages paid to an individual retain the same exemptions that we've always interpreted them to mean. The issue with regards to identifying individuals' funds, Social Security funds are exempt by federal law. Kansas, a lot of our exemptions are contained in 60-2313, I believe. We're not amending that at all. Workers' compensation still retains its exemption. Social Security retains its exemption. And we're not touching anything other than wages here.
So if I might, Mr. Chair, I think we're talking about accounts where there's commingled funds, then possibly exempt funds and proceeds of wages. Generally, proceeds of wages are subject to attachment, whereas Social Security, work comp, number of other things aren't. Is it the commingled account that you're looking towards?
No, we're looking to the decision in Seavers, I believe, has a much broader effect than than we've yet seen. What's going to happen under Seavers, I believe, is that money's in the bank account. All of us, most all Americans, when we get paid, we have our paycheck go to our bank account and we use our debit cards or our credit or our checks to pay our bills from there. That money then becomes exempt while it's in the bank account, and that exemption never goes away, regardless of what happens to it, if you can trace that to their income or wages. And that's never happened before here in Kansas.
What's wrong with that? If they're exempt funds now, shouldn't they be exempt funds forever?
Well, they're only exempt because of the Seavers decision.
Okay. I apologize, Mr. Butler. Maybe you and I are going to have to talk offline, as they say, because I'm not following. I have some other questions, but perhaps I should defer, Mr. Chair.
Representative Schreiber.
Thank you, Mr. Chair, and thank you, Mr. Butler. I was surprised at the amount of outstanding restitution, $257.3 million. What's the probability that ever gets all collected?
Zero.
Okay.
It'll never all be collected.
What would you say would be a percentage that would reasonably be collected?
Over how long of a period of time? I mean, if you saw 20% of that or 30% of that collected over its lifetime, I'd be happy.
Okay. Thank you. Thank you, Mr. Chairman.
Other questions before we go back to Representative Carmichael? Back to you.
Thank you, Mr. Chair. You gave the example that following the State versus Arnett case, that a substantial number of files that had been referred for collection had to be, in essence, returned, if you will, to the client, the judicial branch, because the Arnett decision precluded collection. Did I understand that generally?
Yes.
With the chair's permission, I think it was just yesterday we heard in the Corrections Committee from Sean Jurgensen on behalf of the judicial branch, a concern expressed that if we were to change the law concerning juvenile fines and docket fees and the collection of those, which can go out to commercial collection, if you will, that it might be contrary to the collection lawyer's contracts with the judicial branch, and that perhaps that might cause a problem. And I know I'm kind of hitting you a little bit blind on this, but it sounds like when the Supreme Court said, "Thou shalt not collect on these past due judgments," that you were able to accommodate that despite whatever contractual agreements might be out there. Would the same law, as far as you know, apply if the legislature just changed some of these things and said, you know, something we've decided 200 and some odd $1 million worth of debt that can never be collected ought to be wiped off the books if it's more than 4 years old. Would that pose a problem with your contractual agreements if I got in the mood to amend this statute to do that very thing, which I'm probably not in the mood, but.
Thank goodness you're not. My office has tried to not be involved in the determination of where the money goes that we collect. That's always been the responsibility of the clerk of the court. And so the clerk of the court sends me a dollar amount and says, John owes this amount of money from this case. And we use that $1 amount. So when they ask for us to withdraw the restitution, for instance, we've needed a lot of assistance from the clerk of the court and the OJA going through and finding out how they've applied the payments that have been collected thus far, determining what the balances are in those restitution, and then extracting those from our files. And so if the law gets, if the bill is approved, 2608 is approved, then we're going to still need a lot of help and work from the clerk of the court and the Office of Judicial Administration to know, because they may have accepted payments, voluntary payments over the last few months, and the balances may have changed a little bit. And so we'll need their assistance. If you take that down to juvenile, we currently do collect in some instances for juvenile cases, very limited. But if you take the juvenile information and you want to remove those from the collections process, again, I'm going to need the assistance from the clerk of the court and the OJA to know what is the amount that's due, because they gave me $1 amount that was due for each case.
But if we, in essence, erase the debt statutorily, and you've already got a contract and referral to collect the debt, my presumption number one is you wouldn't go ahead and collect the debt, because that's obviously would be problematic.
Sure.
But I take it in your profession, what happens is the clerk notifies you that whatever this debt is that you are supposed to collect has been otherwise satisfied, whether they've paid at the courthouse or we struck it off the books because we were generous one day. That's just part of the risks of the collection business, at least on these types of contracts, that you may lose it if it gets paid some other way, or if we legislatively wipe out the debt. Is that generally the way that works? Okay.
I would have no claim against the state.
Okay. Thanks. I appreciate that. That may save Mr. Jorgensen some work if he's listening. Thank you, Mr. Butler. I look forward to visiting with you more, though, on the implications of modifications to 602310. Thanks.
Any other questions, committee? Okay, thank you, Todd.
Thank you.
Committee, we have written proponent testimony from the Attorney General's Office and the Kansas County and District Attorneys Association. Anyone else as a proponent? Okay, anyone as a neutral conferee? We have one opponent. I believe he's online, Brian Cox.
Yes, Chairman. Can you hear me all right?
Yes.
Thank you. Thank you, Chairman Patton and representatives, for the chance to speak to the committee on this bill. My name is Brian Cox, and I'm here on behalf or as a member of the Kansas Association of Criminal Defense Lawyers. I also used to practice trial criminal defense, and now am doing appellate criminal defense. Chairman and representatives, I think the biggest problem with this bill, and the reason that I'm opposed to it, is that it's not actually resolving the issue, and it has a huge danger, and I want to make sure to drive this point home. It has a huge danger of, in the future, coming to the point where exactly the concern that Mr. Butler cited of restitution judgments being unable to be collected could happen, and I'll tell you why. Arnett, the case that led to this issue, there were actually two arguments made by the appellant who had been ordered to pay over $30,000 of restitution because she loaned her car to her boyfriend who went out and committed some burglaries. She first argued that ordering restitution without a jury trial on that question, without a jury finding on the amount and the causation of the damages caused, violated her rights under the Sixth Amendment of the United States Constitution and under the case law that we know well in criminal defense, Apprendi. Her second argument was that it also violated Section 5 of the Kansas Bill of Rights. Now, the Kansas Supreme Court rejected that Sixth Amendment federal constitutional argument. It went with the Section 5 Kansas Bill of Rights argument. But the key thing to note here is that that case is not completely over. It's my understanding that a petition for writ of certiorari has been filed. We've got a new justice coming in with the departing justice at the United States Supreme Court having not been one of the more Apprendi favorable judges. And we have dissenting opinions from the likes of Justice Gorsuch, joined by Justice Sotomayor, indicating that they think that the Sixth Amendment argument here, that you have to have a jury determine these issues, has some merit. So there's a danger that whatever the committee does here, if it doesn't provide for jury determination of these issues, there could be a future where restitution judgments do get nullified because of those constitutional jury trial issues. So in my testimony, what I suggest that the committee ought to do instead is just go ahead and provide for that. When you look at that, there might be concerns about what impact that's going to have on the cost of a criminal case to litigate it, et cetera. But I think those would be minimal. A jury trial is something that criminal defendants waive all the time. That's what a plea agreement is. They waive a jury trial, they plead guilty or no contest. In plea negotiations and in my trial practice, I did this all the time. A defendant would also agree with the state that a particular amount of restitution would be due. They agree that that's the value of whatever they may have stolen or something like that. That can still happen. All of the 98+% of cases that go to plea, the state can negotiate with the defendant. They can agree on restitution, or if there is a dispute, they can even negotiate to have the defendant waive the right to a jury trial and have it determined by a judge. In many of the remaining 2% of cases that actually go to a trial or resolve another way, you're already going to have a jury. They can determine that issue with a single additional jury instruction, perhaps a second phase of trial in some circumstances. I'm sure that would be an issue that would be litigated, but you're already going to have a jury. It's not going to be a significant increase in burden for those cases. Overall, what that would do is it would remove the concerns that motivated the Arnett decision. If there is a jury determination, then the statutes can go right back to enforcing them, to having them enforced, just the same way that a civil judgment can be. Mr. Butler can continue to do his work that he had been doing, and individual crime victims aren't going to have to go out in order to have control over that collection. They're not going to have to go out and file their own lawsuit to have that decided in a separate, parallel, redundant civil proceeding. So that would be a huge benefit. What little burden that there would be where a jury might be called when otherwise it wouldn't to determine restitution. I think that would be outweighed by the number of parallel cases that would be reduced in the civil side of things. I want to add a little bit to my written testimony based on what I've heard from Mr. Butler, and this is really what I think is maybe a big should be a concern with the bill as it's written. When you look at the Arnett decision, the reason that they said that there either needs to be a jury or we've got to change things is that they said that criminal restitution cannot be essentially identical to a civil judgment. That's jury issue and preferred many to strike the parts that made it similar. There's another option, the bill as it stands kind of steps in that direction, steps towards making criminal restitution a civil judgment again. And so I'm concerned that even under the Arnett decision, there's a risk here that making the changes in this bill in an attempt to fix it is just going to get struck down by the Kansas Supreme Court again. And I'd be happy to answer any questions from the committee.
Any questions, committee? Representative Carmichael?
Thank you, Mr. Chairman. Help me with my bad memory. In a civil tort case, the determination of the amount of damages is determined by.
That would be determined by the jury.
Wait, we had a technical malfunction. The amount of damages is. The amount of damages is.
If you could quit repeating yourself, Representative Carmichael.
Touche, Mr. Chair.
And
Mr. Chair.
I'm sorry, I believe I may have some connectivity issues. Yes, the amount of.
No, sir, upon a preponderance of the evidence. But if
I apologize.
Okay, he can't hear me.
You were muted there for a moment, and I couldn't hear part of it.
You're saying he needs to be unmuted? Okay, sir, if you could try muting your microphone. Okay, there we go. Civil case, damages determined by a preponderance of the evidence. Criminal case, are damages for restitution determined beyond a reasonable doubt, or is it a preponderance of the evidence or some other standard?
If the Sixth Amendment Apprendi argument wins out, they would be required to be proven beyond a reasonable doubt. It's my understanding, however, that I believe under the current case law, and I may be incorrect on this, I don't have it in front of me, I believe that the judge only has to determine it by preponderance. But the Apprendi issue could change.
Okay, what's the Apprendi issue? Is that a case?
Yes, Apprendi was a United States Supreme Court case that basically says anything that increases the punishment in a criminal case, other than the fact of a prior conviction, has to be proven to a jury beyond a reasonable doubt.
Thank you for
the question is, does that also extend to restitution?
Thank you for refreshing my recollection. Thank you for your patience, Mr. Chair. I'll attempt not to ask the same question 4 times.
Any other questions, committee? Okay, thank you. Any other opponents? Very good. I'll close the hearing on House Bill 2608 and open the hearing on House Bill 2694 and have Natalie come back up. So let us know what it's about. Thank you, Natalie.
Thank you, Mr. Chairman. House Bill 2694 would enact the Third-Party Litigation Financing Consumer Protection Act. It would require the regulation of litigation financing. Section 1 names the act and provides for the definitions to be used throughout the act. Section 2 provides that a litigation financer shall not engage in a litigation financing transaction in Kansas unless they are registered as a litigation financer pursuant to this section. The Secretary of State would be charged with registering those litigation financers, and they would be required to register them if they meet the requirements for registration and pay a $100 filing fee. A litigation financer would be required to file with the Secretary of State a surety bond of at least $50,000. Section 3 provides acts that the litigation financer is prohibited from engaging in. It also provides that a legal representative or a medical provider for a consumer shall not have a financial interest in litigation financing or receive a referral fee from any litigation financer. Section 4 provides that the terms of a litigation financing agreement shall be in a written contract. The bill provides for the disclosure requirements that are to be listed in those written contracts. If a consumer is represented by a legal representative, then that representative shall acknowledge that they have not and will not receive or pay a referral fee. If a legal representative is a party to a litigation financing agreement, then they would be required to share that agreement with the consumer. Section 5 provides that a consumer or a legal representative would be required to provide all parties to the litigation with any litigation financing contract or agreement under which any person other than the legal representative for that consumer has received or has a right to receive compensation or proceeds from the consumer contingent on that civil action. And the existence of a litigation financing contract or agreement is an allowable subject of discovery in all personal injury cases. Section 6 requires litigation financiers to file an annual report with the Secretary of State. It also provides the requirements that report has to contain. The Secretary of State would then report to the House and Senate Judiciary Committees and the House and Senate Commerce Committees with a summary of the reports received. And that summary would also be required to be posted on the Secretary of State's website. Section 7 provides that the act applies to any class action lawsuit. Class members would be required to be advised if the proposed class attorney has a legal or a financial relationship with a litigation financer. This act does not apply to litigation financing provided to commercial enterprises unless that situation somehow arose from a personal injury claim. A violation of this act would make a litigation financing contract unenforceable. And if passed, these provisions would go into effect on January 1st of 2023. And I can take any questions.
Do you have any questions? Representative Carmichael.
Thank you. Ms. Scott, if I represent a plaintiff and I advance my own funds to pay the expenses of the litigation, sometimes I get upside down by $50,000 or $100,000 for expert witnesses. Does that make me a litigation financer, and do I have to comply with this, or am I somehow exempt?
No, Mr. Chairman, Representative Carmichael. So we're talking about third-party financiers. So if you, as an attorney, have a contingent fee with your client, that is not what we're talking about. We're talking about a third party financing you.
But I'm talking about advancing funds on behalf of a client, not my contingency fee contract, which says I only get paid if I win. I think the answer would be the same, I think.
Yes, I believe so, but I might have to do a little bit more.
I'll do more looking myself too. Thank you. Appreciate it.
Representative Heiberger.
Thank you, Mr. Chair. Natalie, I'm looking at some of the definitions here on the first page, litigation financer and litigation financing. And is it the case that any person who takes any action toward financing, any third party takes any action toward financing a litigation, does that person qualify as a litigation financer? Or is it more limited than that?
I believe that that they would be covered. So if you're looking at the definition of a litigation financer, it would be any person or group of people in the business of financing litigation. So I think it would be any third party who would be financing that litigation other than the legal representative.
So I guess I was a little confused by the phrase "in the business of litigation financing," but that would mean any activity that involves litigation financing, however limited.
Yeah, I mean that is an interesting question, but I do believe probably, I mean, if they're normally, I guess there we would just say that's, someone who is engaged in litigation financing, but I suspect that would still apply.
Okay, thank you.
Any other questions for Natalie? Okay, thank you, Natalie. Begin with proponents. And Eric is here. Eric Stafford's up first. He's bouncing back and forth between ag, so glad we timed this.
Yeah, thank you, Mr. Chairman. I'm getting texts that they're on to questions for the proponents, and I will shortly be up down in Ag to testify on fake meat. So I don't know what's more fun, third-party financing or fake meat, but this is not an imitation hearing if I'm going to have any pun joke for today. My name is Eric Stafford, Vice President of Government Affairs for the Kansas Chamber. Appreciate the opportunity to testify in support of House Bill 2694. Just yesterday, in fact, we testified in support of Senate Bill 152, a bill that we introduced last year to disclose third-party financiers to litigation. It has a disclosure requirement. There are some costs that could potentially be collected in a case of like a frivolous lawsuit that could come back on that third-party financer. But basically, the goal here is to address what has become a growing trend of third-party investments or hedge funds. There is now an association. I assume that they're testifying in opposition to this bill as well. There's a trade association that exists to represent these individuals who now invest in litigation. And that's bringing up some ethical questions on what influence that possibly have on the attorneys representing the plaintiffs in the case. It was asked yesterday, would this information go to the jury? The intent is not. The intent is just to make the defense aware, as well as potentially the judge. But the purpose here is to make the defense aware. If somebody's pushing for a settlement or some sort of effort on the defense side, and that's being pushed because there's an outside financial interest to the case, that might influence the employer, in our case, business's decision on whether or not we should. And those facts, in our view, should be made known to the defense on whether there is some sort of third party that has an interest in the financial outcome of the case. The Institute for Legal Reform from the U.S. Chamber issued a white paper that basically this trend started, or this financing arrangement started in Australia and then worked to Europe and has now made its way to the United States and did so about 10 years ago. They estimate it's about a $10 billion industry. But we don't really know because it's not disclosed. Disclosure is a requirement in this bill. This bill is much more extensive than Senate Bill 152, but has some other parameters and safeguards in place that I think are probably good, dealing with the ethical side of contingency fees between physicians and attorneys and clients. That said, Wisconsin has passed similar legislation closer to Senate Bill 152. Some district courts, Northern California, District Court of New Jersey, have issued disclosure rules for third parties to the case. And there have been some other states, a few other states that have passed similar reforms. Interesting tidbit on a completely separate issue, Senate Bill 150, dealing with deceptive advertisements. Hopefully that gets to you guys here in the next couple of weeks. That West Virginia law is being challenged in federal court, district court. The plaintiffs were successful as a restriction on free speech at the district court level, but the Federal Court of Appeals is hearing oral arguments the week of March 8th. On the amicus brief from the U.S. Chamber, there's a box that checks, do you have a financial interest in the outcome of this case? And the U.S. Chamber has that checked, no. So if we are having parties requiring third parties submitting briefs to the case, why is it unacceptable from the opponent's standpoint to have any third party that's looking to invest in litigation? Why is it unacceptable that it be disclosed on their end as well? So as I said, this definitely has some more steps and checks and balances from the ethical standpoint. Behavior that are positive as well. But overall, we support the concept of this proposal and be happy to answer any questions. And Mr. Chairman, if I may, do you mind if I run downstairs to go to that hearing, and I'll come back up as soon as I'm done talking fake meat?
Got it. We'll keep working through this.
Okay.
Just get back as
Thank you.
quickly as you can. Eric Wareham. Is Eric here?
Yes,
Oh,
Mr.
online.
Chair.
There you go. Now I see you.
I'm the shorter but better looking version of Eric in this hearing. So, Mr. Chairman, members of the committee, my name is Eric Wareham, Vice President of Government Affairs for the Western Equipment Dealers Association. Represent 147 dealer locations in the state of Kansas, primarily farm equipment, but also some construction. And this issue, you might be wondering, why are we involved in third-party litigation funding? And it was an interesting issue to get roped into, and it came directly from our membership that was concerned about the increasing amount of litigation they were seeing in our industry and things to do about it. We reached out to the chamber, we talked to a lot of folks, and one of the trends that may be contributing to the increase in litigation, and again, we're unaware of it because we don't have the transparency, is this issue of third-party litigation funding, or as I like to call it in layman's terms, lawsuit investors. And you may ask, well, and I ask the question, is this an issue? And Eric Stafford is right. I think he actually undersold the amount that is estimated the size of the industry. I think it's at 17 billion now. And what is more interesting is that it's estimated that 52% of this industry is in the U.S. And so that has occurred within the past 10 years. And, to a large extent, some states used to, or still do, entirely prohibit third-party litigation funding. There's an antiquated term called champerty that is a third party having an interest in litigation. And states like Kentucky, for instance, currently prohibit third-party funding litigation. But we're not looking to prohibit this. What we're looking for is transparency. And this is nothing new. Eric Stafford alluded to it. There are 6 federal appeals courts that currently require a disclosure of litigation funding during the discovery process. There are 24 U.S. district courts. And then just recently, West Virginia, 2 years ago, I believe it was 2 years ago, passed a bill in this regard. And then the Wisconsin state legislature passed a bill mandating disclosure during the discovery process. And so, I can get into the benefits of transparency, but I think they're pretty obvious. In this context, it certainly improves the claim settlement process, reduces the transaction costs, and I think increases confidence in the outcomes. There are additional, as Eric talked about, consumer protection standards involved in this particular bill, creating sideboards to the agreements to prevent abuse. There's a lot of articles, if you just Google it or search it, you can find a lot of articles, and I could send them to the committee as well, that discuss and relate to abuses in this area of financing. So with that, I will stand for any questions you have. Thank you for your time.
Questions, Representative Ralph?
Thank you, Mr. Chair. Thank you, sir, for being here today. I'm curious because as I listened to your testimony, several of the things that you mentioned about the benefits of this legislation talked about transparency and a concern about increased litigation. And I think you said the potential to improve settlement prospects. And then fairly late in your testimony, we talked about consumer protection. So I noticed the label on this talks about consumer protection, but actually this is more about, as I understand it, your members, if you will, I guess, wanting to know whether there are litigation financiers involved in litigation. Is that right?
Yeah, that's certainly I think the primary purpose. And if you look at the Senate version, it targets, I think, primarily the disclosure requirements. But there's other elements in this bill as well. Yes.
So as I understand it, and particularly when we're talking about litigation, I'm not all that, hate to say it this way, I'm not all that concerned about transparency, because in any litigation, the court will tell you what information you can have as it relates to that litigation, or what information you can't have. Would that be a fair statement?
It is a fair statement if you're talking about, there has to be an authority that the court relies upon to require that disclosure. And so, for instance, the federal courts have done that, but at the state level, the disclosure during discovery is not a requirement. And I don't think we see judges often do that because there's not a statute that allows for it.
I guess I would disagree only to the extent that it was frequently my experience that trial judges required you to do whatever they darn well pleased within their courtroom, statute or not at that point. But I guess one more question, if I might, Mr. Chairman, specifically looking at, and if I can get my computer to wake up, I'm looking at the bill on page 5, or toward the top of page 5, around line 6. It appears to me the language of this particular bill would also require that there be, with the language that's used there, a disclosure without requirement of actual request for discovery, that there would be a disclosure of what I believe is captured there as subrogation interest, whether it be medical bills or other insurers, such that if a plaintiff has reached some agreement with some providers, whether it be medical bills or property damage or whatever, that the defendant would be entitled to know what that resolution of those underlying claims were prior to a resolution of the lawsuit. Am I reading that correctly?
Representative, I'm reading through it too. We may need to discuss that. I can circle back to you because I want to provide you the right answer, but I don't think it's the intent to reach to the underlying agreements between medical providers. This is more about disclosure of parties and entities that are investing in the litigation.
Well, as you look those up, and I would appreciate getting that information. I'm specifically looking down the line at around line 6 on page 5, where it talks about disclosing anyone who has a right to receive compensation or proceeds from the consumer that are contingent on or sourced from proceeds of the civil action, which, as I read it, would encompass, for example, medical bills with a hospital that may have been compromised in some fashion. And so you would make by statute that be required to be disclosed before you got to, as you said, facilitating your settlement prospects. So that's the piece I'd like for you to check on for me, if you would, please. Thank you, Mr. Chair.
Additional questions? Okay. We have written proponent testimony from the American Property Casualty Insurance Association, from Fuel True, and from Case Leiden PC. Any other proponents? We'll get back to Eric Stafford when he returns. We'll find him and bring him back. Neutral written testimony from the Secretary of State's office. Anyone else with neutral testimony? Okay, opponents. We have, it's Tara, not Eric. We have another Eric. Eric Schuler. And is Eric online? Yes, you're waving at me. You're up.
Thank you, Mr. Chairman. Mr. Chairman, my name is Eric Schuler. I'm the president of the Alliance for Responsible Consumer Legal Funding, also known as ARC. ARC is a trade association that represents companies that provide financial assistance to consumers who have a pending legal claim, such as a car accident. The money that we provide them goes solely for household needs, such as making the mortgage, car payments, and keeping the lights on, while their claim is making its way through the legal system. The average amount of funding that we provide to consumers is only about $2,000. And we're very clear that the money that we provide to the consumer is not to be used to further litigation. In fact, in other states, we have passed legislation. We specifically state that the funds we give the consumer cannot be used for this purpose. ARC is not opposed to regulation of the industry. In fact, we welcome it. But we do have some concerns with this particular piece of legislation because it's currently drafted. It would encompass our industry, and I don't think that's the intended purpose. I think the intended purpose is to regulate the companies or the industries that provide funds for the litigation and actually pay for the litigation cost, which none of our members do. Like I said, unfortunately, the legislation is very broadly interpreted. What we'd like to do is offer a couple of solutions, if we could, is under the litigation financing definition, is really just add a line that says litigation financing does not include funds to a consumer or for individual for household expenses or for purposes other than funding of the litigation or the relevant claim. If this legislation were to go through as is without that particular change, we do have some other additional concerns with it if it goes through as is. One of the issues that is in the prohibited acts is there an anti-assignment provision. And what states is assignment or securitization of litigation financing contracts in whole or part is prohibited. Unfortunately, what this does is this cuts off the funding mechanism for the companies. This basically takes out their ability to get any capital for the companies. When this is passed in other states, such as Tennessee, the companies pulled out of the state until it was resolved back in 2017. Again, we'd be happy to work with the committee and the members to come to a happy resolution on this. Also, too, if it were to be kept in place as is, requiring the mandatory disclosure does put the consumer at a disadvantage. It basically tells the other side that the consumer is in a financial bind and had to go to outside resources to help ends meet. Similar language was passed in West Virginia and Wisconsin, as was stated earlier. But basically, as a result of that, consumer legal funding as a non-recourse product is not offered in either of those states. If the consumer receives funds from another financial source, those don't have to be disclosed, just this type of transaction. And then finally, on the annual reporting that's required in the statute, it does put an undue burdensome on the companies. The section of the report should be stricken because the fact of the company information that's required on an annual basis is usually done at the beginning of when a company registers with the state. And to have that done year after year after year to prove something that's already in there is really an undue burden for the company. It should only have to be updated when the facts change. And the other thing which is of concern to us is it requires that all these financial transactions be disclosed to the state. So the state of Kansas would know onto every single consumer how many times or which consumers took out these financial transactions by name and by address. Again, that's kind of getting into the civil liberties of the consumers. As I was stated before, the average amount that we provided consumers is only about $2,000. If you've been involved in any sort of litigation, you know that $2,000 will not cover any small portion of the amount needs to bring a case forward. That's why I believe that we're not the targeted industry of this piece of legislation, but unfortunately an unintended participant in it. We'd be happy to work with the members of the committee in either amending us out of the bill or making it clear and intended for those companies that fund the litigation and not for solely those who need financial assistance while their case is pending. We'd be happy to work with you in perfecting this bill, and I'd be happy to answer any questions.
Any questions, committee? Do not see any. Thank you. Next,
you.
David Morantz.
Good afternoon. Good to see you all. Thank you, Chairman Patton. My name is David Morantz. I'm an attorney in Kansas City. I practice in the field of personal injury. I've testified in front of many of you before, most recently via web. It's nice to be back in person. I'm a member and a past president of the Kansas Trial Lawyers Association, and I'm testifying today on behalf of that organization. I fortunately haven't had to deal with litigation finance companies or litigation finance agreements. Part of that is a function of, like most plaintiffs' firms in Kansas, our firm funds its own cases. I'm not sure of any Kansas firms that go to outside sources to get funds for cases. And I've also been fortunate that my clients have not needed to get the type of living expense loan that you just heard about. And on the few occasions when they've had, I've strongly discouraged them from doing so because I found that the rates can be quite high and they can be better off getting funding from other sources. Now, I give you those two examples for two reasons. One, this doesn't happen very often in Kansas. You've heard a lot of horror stories, and there was a horror story yesterday in the Senate Judiciary Committee where a lawyer had to conjure up a hypothetical from a case that happened in Missouri. The case didn't even involve a litigation finance company. It was just a story of what if it did. I think you need to press the proponents on whether this really is an issue in Kansas, because I'll submit to you that from my experience and other trial lawyers' experiences here, it's not. But the second reason I give you those two examples is I've had to learn a lot about this issue in the last few days in this industry. And I've found that it's very helpful to think about it in two realms or two spheres. And you've heard a little bit about that so far. The first realm is the litigation finance houses, and they fund big time corporate primarily lawsuits. They're often intellectual property lawsuits. Sometimes they're class action cases. They might be cases that affect the equipment dealers, but I'm a little puzzled about why they're involved in this case or in this statute, because the statute specifically says it doesn't apply to commercial enterprises or to litigation financing in regard to commercial litigation. That's in Section 7. So that's the first realm that we're dealing with in this industry. The second realm, like you just heard about, are the consumer finance organizations. They don't fund litigation. When people get injured, when they lose a loved one, they often have no income. They need a way to get by. And sometimes they have to go to consumer finance funders. And that, I'm not sure which entity this bill targets, but it undoubtedly covers both. And as an attorney who represents consumers and folks who have been injured, if there's a way to craft a bill that provides for good regulation of short-term, or however you want to term it, loans to consumers who have no other way of getting financed, we'd be open to discussing that. But there's a major problem with this bill, and the previous conferee touched on it, and that's the disclosure requirement in it. Now, I'll submit to you that as great a work as this committee does and the folks in this building do, I don't know if you're going to come to a solution on this disclosure agreement. And by example, you've heard a lot about the federal courts so far. In 2014, the U.S. Chamber of Commerce introduced a proposal. They wanted to have the Federal Civil Rules Committee. That's a huge committee of judges, law professors, attorneys who write the federal rules of civil procedure. It's the counterpart to our Kansas rules. The U.S. Chamber wanted them to include a similar disclosure agreement that's in the bill that's in front of you. And that language, Representative Ralph, that you asked about in Section 5, that's model language from the U.S. Chamber of Commerce. They've been including that in bills all across the country and also trying to push it to change the federal rules. The Federal Rules Committee took about 8 years on this issue, and they couldn't figure it out. They had competing interests. They finally, in October, sort of threw up their hands in the way lawyers and judges do. They wrote a very long 20-some page report about how complicated this issue is and that they weren't able to reach a conclusion on it. And if some of you would like to read that, I can forward it to you because it is sort of interesting and sleep-inducing. I do want to focus now, though, on that disclosure requirement and why it's so onerous and such a problem. Litigation financing, like we're talking about today, has nothing to do with the merits of a case. Nothing at all. It doesn't affect whether a party did something right or wrong, and it doesn't affect that party's damages. The jury doesn't need to know about it, shouldn't know about it, and so there's really no reason to get into it. But what it does is, if you make that required disclosable information, you drastically alter the balance of power in these cases. Because right now, plaintiffs and defendants ideally are on equal footing. And this stems from the old idea that we're all equal under the law. On the top of the US Supreme Court building in DC, it says equal justice under law. This disclosure agreement would let defendants and their insurance companies know that a consumer is financially distressed or that a plaintiff is financially distressed. And think about why that's important. Let's say you need to buy a car and you go onto that car lot. And let's say that just yesterday you were in a wreck, you lost your car, you don't have any transportation, and you've got to have transportation to get to work tomorrow. Are you going to let the car dealer know about that? Heck no. The car dealer knows about that. He or she's not going to give you any type of good deal. They're going to know you're under duress and you're going to end up paying more. And it's similar here. If an insurance company or a defense attorney knows that a plaintiff is financially distressed, they're going to lowball them. They're going to end up paying pennies on the dollar to settle a case, and that plaintiff's not going to get what they deserve. That's why this issue is so onerous. That's why the disclosure requirement is so onerous. And when you combine it with the fact that it's not going to come into trial, it's not necessary for discovery, why would we even make that disclosable? Why would we require the disclosure of it? If it does come up as an issue in a very specific or rare case, I'm having trouble thinking of it, but a defendant can always go to the court. There is nothing in the rules that say that those agreements are not discoverable. A defendant could go to the court and say, Judge, we need to get this agreement. The defendant can come up with a reason why, and the court would decide that. It would be on a case-by-case basis. It wouldn't be on a one-size-fits-all statute like you have in front of you. To hit some of the other stuff that we've heard about today, there's been some mention of ethical questions that come up from litigation financing. And I think it's important to know that if we're talking about the second realm here, the consumer finance organizations, those don't fund litigation. So those folks don't have any control or influence on what an attorney does. If we're talking about the first realm, the large finance houses that fund big time, primarily commercial cases, the attorney and the client drive those cases. They make the decisions. The financiers can't make the decisions. There are ethical rules that prevent them from doing that and that prevent attorneys from allowing them to do that. So don't get distracted by thoughts about ethical questions. The client and the attorney are the masters of the case. I've given you a lot of information. It's a fascinating topic. It's a fascinating industry. Like I said, I've learned a lot about it in the last few days. If you all have any questions, I'm happy to try to answer them.
Any questions, committee? Thank you, David. We also have written opponent testimony from the American Legal Finance Association and from the Kansas Bar Association. Any other opponents? Okay, let's bring Eric back up. Anyone have questions for Eric? What happened to your bar? Okay, guess you got off lucky, Eric. I'll close this hearing on House Bill 2694. Now let's look at House Bill 2508, committee. And we will start off as soon as Natalie's ready. Give us a brief overview of what this bill is.
Thank you, Mr. Chairman. House Bill 2508 would require the retention of fingerprints by the Kansas Bureau of Investigation for participation in the federal Rat Back program.
Any questions for Natalie? See any? Are there any amendments? Not. Is there a motion? Representative Hoheisel?
Thank you, Mr. Chair. I move that we pass out HB 2508 favorably.
Second. Representative Schreiber, discussion. Do not see any. Representative Hoheisel, you may close. For the motion, all in favor say aye. Aye. All opposed say no. Motion carries. Those wanting their affirmative votes recorded: Hoheisel, Carmichael, Heiberger, and O'Hobison. Next, let's look at 2574.
Mr. Chairman, House Bill 2574 would establish time limitations for awarding compensation for mental health counseling by the Crime Victims Compensation Board. And then it would also increase certain amounts for the crime scene cleanup and the funeral expenses.
Do you have any questions for Natalie? Any amendments? Their motion, Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2574 favorably.
There a second? Representative Wheeler, discussion? Okay, back to you, Representative Hoheisel.
I close.
Heard the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. The yes votes wanting to be recorded: Hoheisel, I think. Hoheisel, Carmichael, Heiberger, and O'Hobison. Now let's look at Senate Bill 102. Yeah, let's do the brief overview and we'll see where where we go.
Mr. Chairman. Senate Bill 102 would require earlier notice of an anticipated release from custody of a person who might be a sexually violent predator to the Attorney General and a multidisciplinary team. And it would also specify where those individuals would be detained during their civil commitment proceedings.
Questions for Natalie? You'll recall this, we heard this bill last year. We heard it on March 16th. It passed out, not that this matters, but it passed out of the Senate 39-0, came over here, and it slowed down when it got to Senate Judiciary. House, oh yeah, sorry, House Judiciary.
We work hard.
We do work hard over here. Just again, as reminders, if you've not looked, we had proponent testimony from the Sheriff's Association, from the Attorney General's office. That was it. We had neutral testimony from the Department of Corrections. And if you were to look at theirs primarily had to do with the cost involved, which you'll also see reflected in the fiscal note. I reached out to them to see if there were changes we could make to change that fiscal note, and they didn't come up with anything. So they continue to have the same neutral concerns that they had. And then we had opponent testimony from the Kansas Association of Criminal Defense Lawyers. I reached out to them, and I don't believe they did acknowledge I got the email, but they never responded back with any changes they would suggest at this point in time. So that's where we are. The fiscal note, there is one much larger than we normally deal with in this committee. My understanding, though, is that would be a fairly short-term fiscal note because this is kind of speeding up the process for a number of these individuals, and so it would cost money to do that speed up. But then once they get caught up, hopefully that money wouldn't be long-term. Hold on one second. I'll find that. So the fiscal note. Yeah, there you go. 1.13 million. To hire a number of additional staff to process this. Are there any amendments? I have one, which I almost forgot. Yes, Representative Kincannon.
On that fiscal note, was that going to be one time or is that annually?
It's on it. It has FY22, and that's all it lists. Just an FY.
Yeah, I mean, in visiting with them, my belief from hearing the testimony is it may be more than 1 year, but certainly shouldn't last forever. Because again, once they get caught up, you shouldn't need this additional staff.
Thank you.
Okay, so Kathy should have an amendment to send out. It's a technical amendment updating the dates since this bill was originally introduced in 2021 and it's now 2022. Watch for that to hit our email boxes. Actually moves all the dates forward by 1 year. You all had a chance to see it. I will move my technical amendment. Is there a second? Representative Ralph, any discussion? Not all in favor, say aye. All opposed say no. Motion carries. Any additional amendments? Okay. Is there a motion on the bill? Representative Hoheisel.
Thank you, Mr. Chair. I move that we pass out SB 102 as amended.
Is there a second? Representative Neely, discussion? Seeing none. Representative Hoheisel, you may close.
Close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Those wanting their yes votes recorded. Hoheisel. That's the principal bill. Hoheisel, Carmichael, O'Hobison, and Heiberger. Let's look at 2620.
Mr. Chairman, House Bill 2620 would create the crime of interference with the conduct of a hospital. And then it would also increase the criminal penalties for battery of a healthcare provider who is employed by a hospital.
Any questions for Natalie? Are there amendments? Representative Kincannon.
Mr. Chair, I have an amendment that Natalie's going to send out. Do you want me to
Yes,
explain
please
it?
start.
So I had asked in the hearing about the physicians that are not employees. So this, I don't have the language in front of me. This amendment would include, the wording of it would include physicians as well as students and volunteers.
There we go. I just got it.
So it states employee means a person employed by providing healthcare services. Sorry, this is really tiny. At volunteering at or participating in an educational course of instruction at a hospital.
Okay. Any
Mr. Chairman, I would just add, so that would be the change that we're making to the new crimes of interference and aggravated interference. And then if you go down to the battery of a healthcare provider, we, in that definition of who qualifies as a healthcare provider, we're saying those folks who are employed by or providing healthcare services at a hospital.
Any questions? Representative Curtis.
I just want to make sure I'm clarifying just, so this is what you, when you asked the question, it was those healthcare workers that are working, perhaps physicians that are on a contract with the hospital. Is that correct? They're not, does that include them?
Well, then not, yes, it could include those with a contract, but it could include an independent practice that maybe that's the hospital that they admit patients. So they're making rounds, cover the emergency room, that sort of thing.
Mm-hmm. Thank you. That's what I thought it was. Thank you.
It also includes volunteers. I don't remember, somebody on this side asked that question.
And students.
And students, so yes. Representative Carmichael.
I think we've covered my questions. Thank you.
Okay. So let's make your motion, Representative Kincannon. Is there a second? Representative Hoheisel. Any further discussion on the amendment? Seeing any, you can close. Heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Any further amendments? Staring at Natalie. She won't make eye contact. Okay. Okay, not seeing any. What's the pleasure of the committee on the bill as amended? Representative Kincannon?
I don't want to steal Representative Hoheisel's thunder here. Mr. Chair, I move that we pass out House Bill 2620 favorable as amended.
Is there a second? Representative Neely?
Oh, boy.
Oh, sorry. There's a delay, Representative Keither. Okay, any discussion? Seeing any, you can close. Oh, yes, Representative Heiberger. Thank you, Representative Keither.
Thank you, Mr. Chair. I'll try to be brief and not repeat everything I said at the last meeting. I'd really like to support this, but I still have not seen any evidence that increasing penalties like this do anything to deter the kind of behavior we're trying to deter or decrease the number of events. And Ed Klump gave an example in the hearing testimony of raising the penalty for a third shoplifting, but it's a different sort of crime. It's a crime that's done, consciously and intentionally. And almost all of the incidents we heard described at the hearing that are happening in hospitals are done by people either with mental illness or serious anger management issues. And so I don't think increasing the penalty here is going to change the outcomes at all. I think this is a prosecutor issue. And so, although I'd love to send a gesture, to my colleague, my friends who work in hospital situations, I don't think sending gestures is a good basis for criminal law. And I'm going to reluctantly vote no.
Further discussion? Representative Carmichael.
Thank you, Mr. Chairman. While I agree with my colleague, the wise representative from Lawrence, that this is just a gesture, I'm not as principled as he is. The people who offered these bills are friends of mine in the legislature, so I'm going to vote aye.
Any further discussion? Now you can close.
Thank you, Mr. Chair. So I've got a few comments I want to make on this. So I think that we can all agree that this is not acceptable behavior. It's an issue. By the way, there's a Facebook group that's called Silent No More Foundation. Take a look at that. You can see what's going on nationally. So I really believe that we need to have a multifaceted approach to impact public attitude and behavior on this. And I've been thinking it needs to be something like the multifaceted effort to increase punishment for DUIs and for speeding in a construction zone. That came with increased penalties, but a lot of public education. So in my opinion, this is just one facet in addressing change. So there's been a lot of discussion that this does not solve the problem. Maybe not, but this is a piece of it. There are studies that show that it does help. There's also studies that show that it doesn't. But I think it's important to send that message. There's three messages here. We need to support the healthcare providers. These are frontline people who are taking care of the public. And we need to care about their safety. We need to send a message to law enforcement, as we heard earlier, that the law enforcement does not believe that this is a priority for them. If we increase the penalty, it shows that for us, this is a priority. And we need to send a message to the public and that this is not acceptable and won't be tolerated. When nobody ever faces penalties for this, it's just going to keep going. There are concerns about mentally ill and dementia, but these are health providers and they understand the difference between dementia and a hostile patient that's either angry or inebriated and needs to they need to face consequences for their actions. In that same vein, as far as mental health, it's also illegal to walk naked down the street. But if there's a dementia patient, if this is happening, that person gets picked up and taken care of, and they're not punished. Those are not the people that this is directed at. So, Mr. Chair, we need a culture change, and the change, I believe, begins with this bill. And I close.
You've heard. Do you have something you'd like to add, Representative Wheeler? Yeah.
Close, Mr. Chair, and I think that precludes.
Okay, perfect. You've heard the motion. All in favor say aye.
Aye.
All opposed say no.
No.
Ayes have it. Those wanting their affirmative votes recorded: Neely, Hoheisel, Carmichael, O'Hobson, Wheeler. Oh, not Wheeler. Those wanting their no votes recorded: Representative Heiberger. Okay, committee, we're going to stop there for today. Something, go ahead,
May
Representative.
I now just make a remark?
Yes, go for it.
I agree with almost everything the closing representative said, except that I don't think that the people were blaming law enforcement being the officers responding to the scene. And in visiting with hospital people, including my own and my own community, that does happen. I think the problem lies here in that these crimes are all misdemeanors in some level or another, which means that they are not going to a DA's office or a county attorney's office. They're going to an unelected appointed municipal prosecutor. This is where the education needs to take place. I would encourage the League of Municipalities or anybody else who works with our cities to present the testimony that we heard here today to our prosecutor associations and the municipals. And that's all I wish to say. I'm not casting blame. I think they need to be aware of the problem.
Very good. Thank you, Representative Wheeler. Okay, committee. So for tomorrow, we have 2 asset forfeiture bills, which if you've been here when we've had asset forfeiture bills in the past, I'm guessing we're going to spend most of the day hearing from conferees. I'm hopeful that we'll have time to get to a couple of bills. So we still have 2620 that I mentioned yesterday. No, we just passed that one. 2652, which I mentioned yesterday. And then I think we're ready on the 3 expungement bills, or we can be by tomorrow. Well, let's go ahead and put them on the list. So 2556, 2557, and 2575. And that's probably as far as we can get tomorrow. And then we'll see what we've had after Thursday. We have 1 bill hearing. I don't anticipate it will take the entire time. We'll see. But we're likely will stay until we get done or really close to done. We do have potentially time to work bills on Monday, but my thoughts are if we wait until Monday to work a bill, odds are leadership has already decided what bills we're going to hear next week. And so we're just wasting everyone's time trying to kick a bill out of committee that won't go anywhere. So hopefully we can get wrapped up on Thursday. I do. Yes. Forfeiture bills. 1 second. Those are 2648 and 2640. Any other questions, anyone? Yes. Representative Curtis.
Thank you, Mr. Chairman. I remember that when we heard the civil asset forfeiture bills before, that we did pass something that was for the data collection. Is that going to be part of the presentation? Are we going to see what information is now available? Because I think that is what precluded us from moving forward on civil asset forfeiture.
No, I don't. I'm guessing some conferees may bring that up. Bob, could we get the report from the Judicial Council as well as I think we now have 2 years worth or a year and a half worth of information from the KBI. We'll get that distributed out tomorrow as well, so you can all see that. Good question. Okay, everybody have a good evening. We're adjourned.